Good afternoon, it's Charlotte Robinson from the Chamber of Commerce, and we've been getting lots of questions recently from our members about different things, and we don't have all the answers. So we're reaching out to experts within our membership to get their expertise to help with the questions coming in from our membership. And today's question is around employment law issues and bringing back our staff to work. So I'd like to introduce Warren from O'Neill Associates, who is going to walk us through this issue. Hey, Warren.
Good afternoon, Charlotte. How are you?
I'm doing great. Thanks so much for your time to walk us through the complexities of these interesting times from employment law's perspective. As we've already discussed, we're getting lots of questions from employers saying that they want to start bringing their employees back, but there's some issues. Maybe their employees aren't able to come back because they don't have childcare or they have health issues, or maybe they just really don't feel safe about coming back to work. And we want to know what the employment law issues are on those questions. So can you help us out?
I can help you out. And thanks for characterizing me as an expert. That's the first time I've ever heard that, I think.
Happy to, you can pay me later.
So I've touched on a few of those points in this presentation. So there's, I think, an overview page next. You can flip over to that. I think from my perspective, the general expectation is unless you have some authorized absence from the workplace, then you're expected to show up for work. As we know, those authorized absences changed as of March 2020 when the provincial government amended the Employment Standards Act to include this declared emergency leave and the infectious disease emergency leave, and that was directly in response to COVID-19. So a lot of people's current absences from work relate to that type of leave of absence. And there's a bunch of criteria that basically says in the Employment Standards Act, as long as the Ontario's state of emergency remains in place, and you meet one of the criteria in the Act for a leave, you're going to have a job-protected leave from work. The last I checked, that declared emergency is extended until June 9th, 2020. But as you and I know, that's an evolving figure, so that could continue on.
Perfect. So let's get into what some of those issues are around. What is a job-protected leave of absence?
So as you know, the Employment Standards Act has a whole host of different types of leave. There's parental leave, there's sick leave, and this declared emergency leave that's set out in section 50.1 of the Employment Standards Act. And so just to be clear, this is applying to most employers in Ontario who are provincially regulated, subject to the Employment Standards Act. I've said in some past presentations, there's exceptions for unionized employees. You want to always look to the collective agreement and see what it says about leaves of absence, and also federally regulated employees. So employees of banks, airlines, telecommunications, other federally regulated industries need to look to the Canada Labor Code for guidance on the types of leaves that are available to them. But the majority of employees in Ontario are governed by the Employment Standards Act. And so, from my perspective, when I'm dealing with a provincially regulated employer, that's the first place I go. I look at the Act and I say, okay, I'm advising on an employee who needs to be off work or is asking to be off work. Do they qualify for a job-protected leave of absence? And so I think the most important one to look at is section 50.1, and I made some reference to that on the next slide. And it basically, as long as there's a declared emergency in place and you meet one of the criteria, you're going to be entitled to a leave of absence. One of those criteria in 50.1 is if you've got a declared emergency and the individual seeking the leave is quote unquote needed to provide care to a family member, that person is going to be entitled to a leave of absence. So, the question becomes, is this person needed to provide care? And that's going to be a case-specific question, but certainly that's important to keep in mind.
So Warren, on that piece, if you had two people that were working from home in the same family, is there sort of an expectation that would mean that only one person would be needed to be at home and they couldn't both claim this, or has that not really been addressed at this point because it's so new?
Well, I think there's an important distinction there because, first of all, if the people are working from home, they're not really on a leave. It's more of an agreement with the employer and an accommodation. When you look at job protected leaves of absence, you're looking at a situation where the employee is not actively employed. They remain an employee, but on a leave of absence. In that situation, that's a good example. If you had two employees, perhaps husband and wife, and one of them was able to return to work and the other was able to care for children because they couldn't otherwise find childcare, then there probably wouldn't be a justification for both to remain at home. And of course, it depends on the facts of that specific case.
Perfect.
So there's kind of two subcategories in section 50.1. There's the declared emergency, and then there's a more specific infectious disease emergency type of leave. The distinction is there's not too much of a difference, but you're entitled to a leave in both situations. When you're talking infectious disease emergencies, that's in direct response to actually having either COVID or being suspected of having COVID or being under a requirement to quarantine. So it's a little bit more specific, but you can have a job protected leave even though there's no risk of you contracting COVID or you're not being monitored for it. And then the infectious disease emergency leave is more specific to your personal health situation. The reason that is important is because employers in both situations are allowed to request evidence that you're actually entitled to the leave. You can't just say, oh, I meet the criteria in the Employment Standards Act and therefore I'm entitled to the leave. It's important to keep in mind, though, that we're still not allowed to ask for doctor's notes as that evidence. So other compelling evidence, certainly, the employer is entitled to ask for it, but not specifically medical notes. And I think one of the policy reasons behind that is we want doctors doing medical work and not writing notes for people to authorize them for their absence.
Absolutely. So things like maybe a history of other medical issues based, like what kinds of things would be reasonable evidence? That there was a history, or, I mean, you didn't suddenly develop asthma yesterday. I mean, are there those kinds of pre-existing conditions, or what could potentially be considered reasonable evidence?
Well, and that's a good question. I mean, in terms of reasonable evidence about the lack of childcare, you might have some sort of message or a letter from your childcare provider that says we can't provide childcare. That would be something that would be reasonable for an employer to request if they were doubting the veracity of the employee's request for the leave. Of course, that gives the employer the right to ask that question. If the employer doesn't want to spend the time or doesn't doubt what the employee is saying, then they don't have to exercise that right.
Right. Perfect. Thank you.
You're welcome. So when I say something's job protected, there's the other side of it. So what does job protected mean? To my mind, the most important aspect of a job protected leave is the consequence if an employee is reprised against for exercising their right to a leave. And the Employment Standards Act, like the Occupational Health and Safety Act, has a remedial scheme for an employee who's penalized for exercising their rights under the legislation. So it's very important for employers to take their time and assess, the circumstance of an employee's request for a leave on a case-by-case basis, but also take the time to communicate with that employee and assess their requests. Don't jump to conclusions about the employee's motivations or what you're supposed to do. The reason for that is you can see on this list of things employers are not permitted to do. You can't penalize an employee, you can't terminate them, suspend them, discipline them because they've exercised a right under this act. And those rights are incredibly broad. It includes if the employee asks the employer to comply with the act, makes inquiries about their rights under the employment standards legislation, files any complaints, anything like that, you can't discipline or otherwise penalize an employee for. The reason that's so important is because if the employee was to complain to the Ministry of Labor, an employment standards officer would be assigned to look into the issue, and they have very broad powers. The most extreme of which I can think of would be if an employee is terminated for exercising a right under their act. In the past, employment standards officers have been able to reinstate that employee to their job with back pay to the date of termination. So pretty broad powers. There are rights of appeal to the Ontario Labour Relations Board, but it's just better not to go there at all.
Really important for the employer to be very careful about the circumstances and not get themselves into trouble under this piece.
Exactly. Just so, and it's important that legislation is understood.
Yeah.
Similar issue is going to be work refusals. Now, this is a little bit more favorable to employers, the way that this has been interpreted by the Ministry of Labor recently. Many employees, since the pandemic began, in around March of this year, have made complaints to the Ministry of Labor, and the evidence that I'm giving you is anecdotal, but my understanding is that work refusals or any requests to the Ministry of Labor, complaints about unsafe work, have not been upheld by Ministry of Labor inspectors. That is, the mere belief that you may be exposed to COVID-19 is not sufficient for an employee to refuse unsafe work. However, that doesn't stop the employee from asking questions or raising the issues about what might be safe at work. And the way that can come to a head is if an employee is refusing to perform work because they have a legitimate fear about their own health and safety at work, right? So in the Occupational Health and Safety Act, there is Section 43 deals with work refusals, and an employee has the right to refuse unsafe work, but it has to be legitimately unsafe work. So there's a high threshold to meet to actually establish that the work you're being assigned to do is unsafe. Simply going back to work in the context of, you might contract COVID-19, but there's nothing more than that, is not going to form a basis to, have a work refusal. Having said that, the employee can still ask about their rights under the Act and have those discussions with the employer, and they can't be penalized because there's similar language in the Occupational Health and Safety Act as there is to the Employment Standards Act. No reprisals for exercising your rights.
So this is where it's important for the employer to make sure that they're providing a safe work environment, and all of those restrictions and rules that we've started to see around things like PPE and making sure that you've got hand sanitizers and you're providing those reminders would be really important to be able to ensure that the workplace is as safe as it can be.
Exactly. Employers, supervisors, and employees all have duties under the Occupational Health and Safety Act, and it's generally to ensure you take every reasonable precaution to maintain the safety of workers. If you're a small business and you're starting back up, in terms of what's a reasonable precaution, well, you've got to look at the science and what we know currently. If you are a small business, look to larger businesses. What are they doing in terms of protecting their frontline employees? Is it having a protective shield for your cashiers? That's probably going to be deemed a reasonable precaution, probably something that the Ministry of Labor is going to tell you should be doing if it gets there, right?
Yeah, and the workplace, the Ministry of Labor has provided some pretty good direction by industry already that we're certainly encouraging employers to be looking to see where they fit and what kinds of steps they might need to take, and then also contacting workplace safety and prevention services and those types of folks for their guidance, which is all available for employers at no cost, that kind of consultation.
And practically speaking, even where your risk is low, and Thunder Bay, we're fortunate, I think, is one of those places, it gives employees peace of mind, and that in turn impacts productivity, because if employees feel that they're safer at work, that's going to take their mind off their concerns and allow them to do their job and be productive for the company. So there is a benefit to it.
So you've taken all those pieces into account, but there's still an unauthorized absence. How does that work?
Okay, so if you've assessed what the employee is asking and they say, I just don't want to come to work, well, there's two sides to an employment relationship. The employer is expected to pay the employee, but the employee is also expected to show up for work. If there is no authorized leave of absence and there's no basis for the employee to remain away from work, then the employer should make it clear to the employee that their expectation is to show up. In a circumstance where an employee doesn't show up to work, that can constitute job abandonment. And job abandonment essentially is it's different from a resignation, because a resignation has to be clear and unequivocal. An employee has to clearly say, no, I'm quitting my job, I'm not coming back. But what do you do in a situation where the employee just stops showing up to work? That's more likely to lead to job abandonment. it still requires the employer to reach out to the employee and have a discussion. Are you coming back? If an employee is late to work, you can't just say, oh, they're not here, they've abandoned their job. It's a contextual analysis of what is the employee intending to do. If you have a brand new employee, they work on Monday and they don't show up the rest of the week, there's a good chance that that's going to be job abandonment. But if you have a 20-year employee and you've had an email exchange and they're not comfortable and they're concerned, they're anxious about COVID-19, you're probably going to have to go a little bit further before you can conclude that they're abandoning their job.
Excellent. Well, thank you so much for that, Warren. I see we've got your phone number here if any employers have any questions, and we certainly do appreciate your time and advice so employers can understand all of the different factors involved in these constantly changing situations. So thank you so much for your time today, and I hope that folks will reach out to you with any questions.
Thanks a lot.